Hi, guys. It's Kathy. I hope you're doing well. We have a new judge today. We actually have two new judges today. We're going to go to Colorado for a bit, and then we're going to go to Texas for a bit. So, let's start in Colorado.
Elizabeth Ford for the people.
Mike Emmons appearing with Mr. Scott.
All right, let me start, Mr. Emmons, with 25 CR 117 and 118. Those are set for return filing of charges. Are you in a position to waive formal reading of the complaint and information in those cases?
Yes.
Okay, the record will so reflect. We're also set for preliminary hearing in 25 CR 16. How do you see us proceeding?
Judge, I will not be able to proceed with preliminary hearing on that case. I haven't had a chance to review the evidence or really talk to Mr. Scott about the nature of that particular incident. So we would ask to vacate that hearing, and I would ask to basically set all matters over to August 20th so I can get discovery and review that.
So would you be proposing a continuance of the preliminary hearing and tolling of timeframes or what?
Yeah, actually, I'd be asking to vacate the preliminary hearing for today. We would toll time periods. I'm not asking to reset the preliminary hearing.
Like your status or something like that?
Sure.
Okay. All right, may I inquire briefly of your client as to tolling?
Yes.
All right, good afternoon, Mr. Scott.
How you doing, sir?
Good, good. Thank you for asking. So what we're talking about is the tolling of timeframes regarding your right to have a preliminary hearing within 35 days of the request. Preliminary hearing is a hearing at which the people would bear the burden of proving to the court that there is sufficient evidence to bind the matter over to trial. You're not waiving your right to have that hearing today. What tolling would do is it would pause the clock essentially of the 35 days from the date of request for us to come back for a status conference. Do you understand that?
Yes, sir.
Are you agreeable to proceeding that way?
Yes, sir.
All right. The court will find a knowing, intelligent, and voluntary tolling the defendant's right to timeframes regarding preliminary hearing. That's going to be status conference, all the cases, August 20, is it the afternoon? August 20, 1:30, status conference on all four matters.
Thank you, Judge. The only other issue I'd ask to address today is I believe there's a cash-only bond, and I'm not sure if that's just in one of the cases or if it's in more of the cases. I'm not asking to change the amounts of any bonds. In the 118 case.
That's the only one.
So I guess that's the one I'm talking about. And also in 117. Okay. So those two bonds, I am just asking that those be modified so that they are cash or corporate surety. I think they're still pretty high bonds. But Mr. Scott has been in Los Animas County since 2017, I believe. He has property in Model, and that's where he resides. He's got livestock out there that nobody's taking care of, including goats and, I don't know, chickens, maybe, 9 dogs. That's the only thing we're asking to change about the bond, not the amounts. And Mr. Scott will comply with whatever orders the court may have as conditions of bond.
Mrs. Ford.
Your Honor, the people object to a modification of Mr. Scott's bond in any case. It's the first time that I'm hearing that he has any land and Model, or that he's apparently some kind of a rancher. He in fact lives in Bon Carbo. The address is in Bon Carbo. And to look at some of the individualized factors under 16-4103 subsection 5, G, prior criminal record, Mr. Scott has 34 different cases of failures to appear that I can't quantify. The most recent being May of 2024 is what I found in El Paso County. six felony convictions at this point. But I think looking at 16.4103 subsection 3A, should be of concern here is that Mr. Scott now has 4 open felony cases, 2 of which involve alleged drug distribution, including meth and fentanyl. In 25 CR 16, one of the allegations in that case is that Mr. Scott had a baggie of fentanyl pills on his person in the jail. And when he was being dressed out, in fact, I think the court heard testimony on that when he was in a preliminary hearing earlier this year, when he was being dressed out, the pills were found and he attempted to swallow them to conceal them from law enforcement. He had to be flighted to Colorado Springs because he had ingested so many pills. I believe that Mr. Scott's ongoing accumulation of drug cases and the allegations that he is distributing fentanyl to the community is a danger. And so to protect the safety of people in the community, the people are asking for the bonds to remain as they're set, which I believe are consistent with this schedule in our jurisdiction.
All right, any of the charges against Mr. Scott, and distribution of fentanyl,
Yes, Your
or
Honor.
just possession?
Their case, give me just 1 second, I have the notes here. So 25 CR 37 was an eluding case. 25 CR 117 possession. 25 CR 16 possession with intent, meth, fentanyl, heroin.
Which one is that?
25 CR 16, he had in his possession the distribution of meth was the one that was charged. And then 25 CR 118, possession with intent, methamphetamines. He also had fentanyl in his possession, and he was distributing these drugs near Kit Carson Park, which is one of the special offender charges, in addition to the weapons that he had.
Just briefly in reply, I'm not
Sure.
going to try to defend against the allegations in this case because I don't have any information regarding those at this point. But regarding the property and model, I think that's known to the court. Apparently, Mr. Scott actually had a case in front of Your Honor that was growing marijuana at his property and model. So that's what's in the court's.
I don't recall that specifics about the case, but I
Okay.
do remember that case.
Yeah, so there was no, as I understand it, there was no FTA in 2024 that Mr. Scott was in custody at that time.
So here's the thing, Mr. Emmons and Mr. Scott. I don't disagree that you're good at showing up for court before this court, but what I'm concerned about is you continuing to pick up cases. In 25 CR 117, that case was filed July 22nd, 2025. 25 CR 118, that was filed just the next day, July 23rd, 2025. So that creates concerns for the community, given you continuing to pick up cases. They're becoming more and more numerous each time, Mr. Scott. So with that, I'm going to deny your request today. Your bond will remain as is. I believe that we already set the matter over for the 20th, Mr. Emmons. Is that correct?
Yes.
Okay. All right.
Thank you,
Okay,
Judge.
we're in recess.
Well,
That's a lot of cases. That's a
Okay.
lot of
I'll be
felonies.
there to talk to
That's
you.
a lot of dogs.
You got my card, bro?
Yes, sir.
Okay.
All right. Is it just Miss Morgan now?
I believe so.
Okay.
I wasn't present if Mr. Gabaldon was addressed.
It was.
Okay.
Yes.
Okay, this is not the trial. All right.
Court calls 2020.
This is just a hearing before the trial. Okay?
For CR 120, people of the state of Colorado versus Linda Morgan. Appearances?
Elizabeth Ford for the people.
Your Honor, this is Max Holland on behalf of Ms. Morgan, present and appearing out of custody and in person today for our motions hearing.
All right, good afternoon. The case pulled up here. All right, the court did receive motion to suppress by defense counsel on July 1st and has reviewed that along with the responsive pleadings. Are you prepared to proceed on that, Mr. Holland?
Yes, Judge.
Ms. Ford, are you prepared to proceed on that? All
Yes, Your Honor.
right, who's got the burden on this case?
I would argue that the people do.
I think so too. All right, do you wish to give an opening?
I'm prepared to waive opening or just rely on my pleading. I typically don't do an opening in this type of a.
Mr. Holland?
I'll waive an opening, Judge.
All right, your first witness, Ms. Ford.
Your Honor, I'd like to call Sergeant Hugh Harkin.
All right, good afternoon, Sergeant. Do you swear or affirm under penalty of perjury that the testimony you're about to give this court will be the truth, the whole truth, and nothing but the truth? I do. Thank you, sir. Please be seated. Make sure you speak clearly into the microphone. Ms. Ford, whenever you're ready.
Sergeant Harkin, for whom do you work?
Trinidad Police Department.
How long have you been doing that?
With the police department, I've been there about 9 years.
Okay. Let's see, hold on a second. Let me get the date of this. I'm sorry. Referring to your affidavit. Were you on duty on August 15th of 2024?
I was.
What were you doing that day?
I was patrolling.
In what area?
I was on the north side of town. I was in the area of North Avenue.
Okay. Were you in a marked vehicle?
I was.
Were you wearing your uniform?
Yes, I was.
Was this in the city of Trinidad, County of Los Animas?
That's correct.
Okay. Did you have reason to make contact with Linda Morgan?
Yes, I did.
Do you see her in this courtroom?
I do.
Will you identify her by something she's wearing?
She's sitting with the defense, black hair, and a tank top.
Will the record please reflect that Sergeant Harkin has identified the defendant, Linda Morgan?
The record will so reflect.
Thank you. Sergeant Harkin, while you were on patrol on August 15th, 2024, you made contact with Linda Morgan. Will you describe how she came to your attention?
Yeah, so I was driving eastbound on East North Avenue. I observed a black Nissan pickup. I was driving southbound from Buena Vista, entering East North Avenue to travel eastbound, and then making a right turn to travel southbound onto North Denver. I observed the vehicle come to the stop sign at the intersection of North Denver and Goddard Avenue. When the vehicle approached the stop sign, it did not stop properly. The vehicle stopped past the stop sign, partially protruding into the lane of travel of the westbound lane of travel for East Goddard Avenue. There was also no turn signal activated at this point. Shortly after that, the vehicle began moving forward, activated a left turn signal, and traveled straight across East Goddard Avenue to the gas station that's located directly across the street.
Okay, and I forgot to ask you, were you by yourself on this day?
I was not.
Who was in your patrol vehicle with you?
Officer Hugo Snyder.
So when you saw did you just describe traffic infractions?
I did.
Then what did you do?
When the vehicle pulled into the gas station, I activated my emergency lights to initiate traffic stop on the vehicle. The vehicle came to a stop at a gas pump, and I pulled into the gas pump behind the vehicle and got out of my vehicle to make contact with the driver.
And describe that contact.
Immediately when we had stopped, Miss Morgan had exited her vehicle as if she was not acknowledging that she was being stopped in that moment. I had to advise her that she was being stopped and that this was a traffic stop. at which time I informed her why she was being stopped, being the stop sign and turn signal violations.
And then what did you do?
I requested her to provide her driver's license, registration, and proof of insurance. Miss Morgan got back into the driver's seat of her vehicle briefly, where she reached into a purse that was on the center console and retrieved a wallet. From the wallet, she got her driver's license and handed it to me. She then began fumbling through some paperwork. Ultimately, she was able to provide me with a copy of her vehicle registration. However, after quite a bit of time of looking through paperwork and offering her to make attempts to get insurance on her phone, ultimately she was unable to provide insurance.
So what was the next step in the stop then?
I informed Miss Morgan that I was going to give her a verbal warning for the initial traffic infractions, but that I would be issuing her a citation for having no proof of insurance.
And then what was the next step after that?
I asked her to come back to my passenger side of my patrol vehicle with me while I began completing the citation. I sat in my driver's seat briefly. I had to return to the back of my car, my back hatch briefly, to get my ticket can because I had a passenger and it wasn't in the front where it normally was. I returned back to my driver's seat and made small talk with her while I was starting the process of issuing the citation. While I was doing that, Officer Snyder had requested the passenger of the vehicle to exit the vehicle, and she also stepped back towards my passenger side of my vehicle. At that point, Officer Snyder took over completion of the citation while I deployed my narcotic detection canine around the vehicle.
And when you deployed your canine, what happened?
Well, short answer, he alerted to the presence of narcotic odor in the vehicle.
And while you were doing the dog sniff, Officer Snyder was writing the citation. Is that your testimony?
That's correct.
Okay. What was the duration of the time between Officer Snyder taking over the citation and the time you ran the dog, completed the sniff?
I believe I returned my canine to the vehicle after about 2 minutes and 5 seconds.
And where was Officer Snyder in the citation process when you completed the dog sniff and returned the dog to your vehicle?
I know that he was still on the top half of the.
I do it all the time. Tona, I do live Twitch streams for my videos and things like that all of the time. You guys don't know about. All the time.
Of the citation, he was still completing the driver's information, demographics, vehicle information. Had not made it to the charges or anything like that yet.
So he hadn't completed the citation and everyone was waiting while you did this.
That's correct.
Once you got back, once you put your canine back in the vehicle, did you have another contact with Miss Morgan?
Yes, I did.
What was that about?
I asked if there was going to be anything illegal in the vehicle. I informed her and her passenger that we would be searching the vehicle. Miss Morgan became agitated and she began explaining that there was a methamphetamine bong, I believe, in the back seat or under the driver's seat. And that she was going to get it for us, appearing that she was trying to avoid officers actually searching the vehicle and was just trying to hand over something that may be responsible for the canine alert. I directed her to come back and did not allow her to go back to the vehicle at that point.
And then once you explained to her that you were going to search the vehicle, is that what happened?
Yes.
Okay. I don't have any other questions for Sergeant Harkin at this moment.
Thank you. Cross-examination.
Yes, sir.
This guy, here we go.
Afternoon, Sergeant.
Good afternoon.
You initially contacted the black Nissan pickup truck due to suspicions of violations of the traffic laws, correct?
That's correct.
At that time, you didn't have any suspicions with regard to controlled substances or any sort of drugs or anything?
That's incorrect.
At the time that you pulled over the vehicle, you had not observed anything that would have led you to believe that there were drugs in the vehicle, correct?
Correct.
So you didn't observe any paraphernalia in plain view
While I'm driving behind the Nissan?
at any time?
That's correct.
You didn't observe any activity that was consistent with going.
That's what we need more of. We need more people answering questions in the most stupid way to stupid questions. While I was driving behind her, are you asking me if I saw inside of her car while I was driving behind her?
To known drug spots.
I guess you could go either way with that, but I'll agree with you.
And you didn't observe any like hand-to-hand distribution out of the vehicle.
That's correct.
The stop was about traffic violations.
Correct.
And when you determined that there was no insurance, you decided that you would write a citation for that.
Correct.
That citation could have,
Now, he pulled her over because he knows her to be a drug dealer. So, all right, back in high school, I used to date this cop, and he would bust someone for drugs. They would go in front of a judge, and then they would be right out on the street again. And as a police officer, it would just be so annoying to him that he's arresting the same people over and over and over and over and over again. So these people, like, he started pulling them over for bicycle infractions, anything. He would see the people, he would already know them because he had already previously arrested them so many times, and he would arrest them for whatever he saw. If they ran a red light on their bicycle, that's it. They're getting a ticket, they're getting arrested, they're getting something.
been written at the side of the vehicle, right?
At the side of her
Vehicle
vehicle?
that you pulled over.
I've never done that.
You could not take the paperwork over to the side of the vehicle to fill it out.
There's quite a bit of information that I require from my laptop in my patrol car to complete a citation.
So when you're completing a citation, oftentimes you do that at your vehicle.
Correct.
But there was no reason for you to believe that Ms. Morgan or her passenger should be removed from the vehicle for officer safety.
I think traffic stops are inherently dangerous. I think getting people out of a vehicle, I don't necessarily have to have an articulation of them being armed or anything like that. It allows us to better see their hands, see what they're doing, and it kind of takes them out of their place of comfort.
Okay.
So they may be less likely to do something that they were planning on doing.
Okay. But the purpose of asking folks out of vehicle was not related to officer safety concerns, was it?
I can't agree with that. I would say there's more to it, but I can't agree with solely that.
You're suggesting that you ask everyone to step out of vehicles during every traffic stop for officer safety,
Pretty commonly.
and that your concerns about officer safety are raised when you have observed a vehicle fail to signal and pass a stop sign?
Not necessarily. I'm familiar with these people, however.
Okay, so it might depend on the person based on your prior knowledge of that person, whether you feel safe or not.
I mean, I think most of us, if we pull over Grandma Good Cookies, would probably feel more safe than somebody that's involved in drug culture and the drug world.
Okay, so you said earlier, correct, that a traffic stop always implicates officer safety.
I'm not suggesting that. I'm saying that they are inherently dangerous.
Traffic stops where you observe traffic violations like failure to signal and running through a stop sign are inherently dangerous to officer safety. Am I understanding that right?
The traffic offense doesn't matter.
Okay. I'm not interested in your opinion on what does or doesn't matter. What I'm trying to understand, Sergeant, is whether you were in fear for your life based on your observations of a failure to signal or running through a stop
I have
sign.
to object here. This has been asked and answered. I understand Mr. Holland isn't satisfied with the answer.
Can you ask your question again? I'm sorry.
Yes. What I'm asking is not whether you think it's reasonable. What I'm asking is whether the observations of failure to signal or rolling through a stop sign necessarily put you in the mindset of concerns about officer safety.
The traffic offense did not cause me officer safety concerns.
Okay, thank you. But nonetheless, you asked both the driver and the passenger to step out of the vehicle when you were completing the paperwork, correct?
Correct.
You asked specifically Ms. Morgan, who was to be given a citation, to come sit with you at your vehicle when you were completing that paperwork.
Correct.
Okay. And that was not for officer safety.
Again, I don't agree with that. Just there may be more than one component or reason for having somebody step out of the vehicle, and one of those reasons may be officer safety.
Broadly, I understand that. I can see where maybe we're misunderstanding each other. But in this instance, you've testified you did not have those concerns at the moment.
Based on the traffic offense.
Right. And so when you had her come to the car for a citation for the traffic offense, you were not concerned about your safety. That was not why you did that.
Well, I've kind of hinted towards the fact that there's additional reasons behind that. Yes.
So you may have had suspicions of other illegal activity, but those suspicions were based off of prior interaction or reputation. Fair to say?
Prior interaction.
Okay. But in that moment, you may have had suspicion of other criminal activity, but you were not afraid that Ms. Morgan posed a threat to your life based off what you observed.
Not necessarily.
And then it was at the time that you were completing the citation that you had decided to walk the canine around the vehicle, correct?
Can you repeat that? I missed the first part.
Sorry, yeah, that's all right. So you testified that you actually walked the dog around the vehicle, correct?
That's correct.
So you were in the middle of preparing the citation, but then handed that process off to Officer Snyder.
Correct.
And then walked your dog around the vehicle.
Correct.
At which point you say it alerted.
Correct.
And you kind of hinted at this, I think, Sergeant, but you're saying there may be other reasons why you were suspicious of Ms. Morgan.
Correct.
Based off of prior interaction.
Correct.
And who she might associate with.
Less of that, I would say.
Okay. So based on that, was that a contributing factor for your decision to walk the drug dog around the car?
Our prior knowledge of Miss Morgan?
Yes, sir.
Yes.
I think I have no further questions, Josh.
Can you redirect?
I just have a couple of questions. So to be clear, you didn't ask Miss Morgan to get out of the vehicle.
I'm trying to recall. I know she was outside of the vehicle on her own, as I had testified. When she,
So you didn't have to direct her to get out.
well, I believe she returned to her vehicle. She was kind of sitting in her driver's seat
Okay.
when she was fumbling through her paperwork, but the driver's door was still open. And I don't remember how. I think she came out of the vehicle, and that's when I had on her own. I'm not positive on this, and that's when I had asked her to come back with me while I completed the citation.
Okay. And you just testified that you handed off the citation writing to Officer Snyder so that you could run the dog. Why didn't Officer Snyder run the dog?
That's my dog. He was with me in my patrol vehicle that day. I believe his vehicle was probably in the shop. Typically, when that happens, we ride together, and our dogs only have one handler. It's either him or myself.
Okay, very good. I don't have any other questions. Thank you.
Just one brief recross question. Sergeant, you stated you were kind of unclear on whether or not you asked Ms. Morgan out of the vehicle. Is that correct?
That's correct.
If I'm going to read from your report, and then you can tell me if it's accurate. Is that fair?
Sure.
The report says, I informed Linda I would give her a verbal warning for the stop sign and turn signal violations, but advised her I would be issuing her a citation for being unable to present evidence of insurance. I requested Linda to come back to my patrol vehicle while a citation was completed. Does that sound accurate based on what you wrote?
Yeah, that's accurate. I don't think it answers the question necessarily, but
So did you request that she step out of the vehicle while you were issuing the citation?
no, in my narrative that you just read, I requested her to come back to my vehicle with me. That doesn't clarify that I requested her out of the vehicle.
Okay. That's fine. But you did ask her to step away from her vehicle and then come towards your vehicle while you were engaged in the citation.
That's accurate.
Okay, thank you.
May the Sergeant be released from his subpoena.
He may.
Sergeant, you can remain in the courtroom if you so choose. It's up to you. Your next witness, Ms. Ford.
I don't have any other witnesses, Your Honor.
Mr. Holland, any witnesses?
No witnesses, Judge.
Okay, closing, Ms. Ford.
Your Honor, in order to find that the defense's motion has any merit, the court has to find that there was no reason for Miss Morgan to be stopped, and also that the dog sniff prolonged the traffic stop. And I don't think there's any evidence at all. There's not that I don't think, there simply isn't, that either of those two things are true. The traffic stop, Sergeant Harkin just testified to the moving violations they observed. They conducted a lawful traffic stop. And then pursuant to the case law set forth in my response, as long as it doesn't unreasonably prolong the traffic stop, it's completely lawful for police to run a canine to do a sniff.
Thank you, Patty. Thank you.
There doesn't have to be any reason for that. I think that the defense is kind of alluding to maybe there was no suspicion of drug activity. There doesn't need to be any. But Sergeant Harkin testified that he had prior experience in that area with Miss Morgan anyway.
Wait a second. I was on your side, lady. What did you just say? You don't have to have suspicion of drug activity to bring the dogs out? What? This is America. Yes, you do. You have to have probable cause to do something to somebody. You can't just pull her over for running a stop sign and then just say, oh, well, I think she has drugs.
I just don't think a 2-minute dog sniff while a traffic citation is being written qualifies at all to unreasonably prolonging the stop. So I'm going to rely on my pleadings. The case law is set forth there, and I'm asking the court to deny the defense's motion.
Thank you. Mr. Holland.
Thank you, Judge. First, I have to correct that the people's incorrect statement of the law. It does not need to be proven in any way that the traffic stop itself was unjustified in order for the court to find that the police unreasonably prolonged that stop in order to do a drug dog sniff and search. I also think that the case law at the state level is a little bit more confused or unclear than the people have represented with regard to the issue of reasonable articulable suspicion. The Supreme Court initially, in a case called People versus Haley, had found a right to privacy with regard to drug sniffs, and also based its holding that it was a proper suppression on lack of reasonable articulable suspicion, but finally articulates the still standing principle that a prolonged traffic stop for the purpose of a drug sniff is unjust and can be suppressible. The U.S. Supreme Court in
Before you move on, can I have the site for Haley?
Oh, yes, Your Honor. I apologize. That would be 41 Pacific 3rd, 666. Your Honor, the Supreme Court was then faced, that was a case from 2001, that was settled law in the state for a number of years until the United States Supreme Court case, Illinois versus Cabayas, which held that walking a trained narcotics detection dog around a car that had not been unlawfully stopped and was not being unlawfully detained did not implicate the protections of the Fourth Amendment, essentially saying that a drug sniff is not itself a search. However, Judge, in the Supreme Court of Colorado case, People versus Esparza, the Supreme Court narrows its understanding a bit and says that while it is not a search that indicates a privacy interest, there's still a concern about whether a dog sniff is a consequence of an earlier illegality, so as to require its suppression as a fruit of that illegally of that illegality. And this is from the Supreme Court case, Colorado Supreme Court case, People versus Esparza. That's ESPARZA, 272 Civic 3rd, 367. And so essentially, whether conduct of a particular dog sniff may infringe on a liberty interest so as to constitute a seizure is not foreclosed by the ruling that such a sniff is not itself a search. So it can still be done in a way that is unconstitutional. In the case People versus Haley, that initially relied on a privacy interest, the facts were very distinguishable from Ms. Morgan's case. In that case, Haley was actually arrested on 2 occasions, and the vehicle was left on the road, and the police used the drug dog to sniff around the vehicle after the fact while it was parked. So it had a very different tenor and concern, especially related to the fact that Haley was actually arrested for various traffic offenses. And so search incident to arrest and other concerns are raised. However, here, Judge, we're not talking about an arrest. We're talking about a case in which Ms. Morgan was observed to have allegedly basically rolled past the stop sign and take a left turn without a signal. That furnished the purpose for the stop itself. And then at that time, all the police had reasonable articulable suspicion of criminal activity regarding was just the traffic offenses. The question is whether then the police officers unjustly extended or prolonged the stop. And I hear the people making an argument that because it was only a 2-minute extension of time, that cannot possibly be prolonging a traffic stop. And that's not accurate based off of what the case law says. There's no temporal or timing requirement that's articulated in any Colorado case law that indicates when a traffic stop is being prolonged. It's just that when that stop is being prolonged from the purpose of the original stop. So a traffic stop may be something that takes 10 minutes to complete. If it is prolonged past the necessary time so that police can engage in a search of the vehicle, then that could be an unjustified search. And so it doesn't matter that it took 2 minutes. What's significant here is that the police asked Ms. Morgan to step away from the vehicle for the purpose of searching it. There was no concern about officer safety with regard to Ms. Morgan's activity. She wasn't furtive. She wasn't threatening. She was not observed to be armed in any way. So there was no concerns about her becoming violent. And the officer asked her to step aside for the specific purpose of getting her out of the way so that he could walk a drug dog around her car without any articulable suspicion. Now, it's true that in People versus Esparza, it overruled the earlier holding from People versus Haley, but it also clarifies that reasonable articulable suspicion is still interwoven into the analysis. That essentially, if the stop becomes about something other than what it was initially supposed to be, without that reasonable articulable suspicion, that becomes a prolonging of the stop beyond the purpose. And so these two concepts are interwoven. So I think it's inaccurate based off of the law, which is, by the way, slightly confused on this issue. We have not had this direct issue explained by the Supreme Court. But in the cases that they have observed, they interweave this concept that there needs to be a reason.
CJ, I'm so sorry. It went so fast. Everything was moving so fast, and so many people came that we haven't seen in so long that I was just trying to get through the chat and not miss anything, and I completely forgot. I'm so sorry.
To prolong the stop. And it makes sense that that would be a reasonable, articulable type of purpose. And I would cite
Guys, this is what I was supposed to play yesterday during the live stream, but I forgot because CJ couldn't make it. Hold on. No, that's had the speed. Here we go. It's up as high as it can go. Ready?
Hello from all your Aussie Vipers. Well, some of your Aussie Vipers. Well, just me actually, saying, have a great stream and I'm sorry I missed you today. From all of your, well, no, maybe just one of your Aussie fibers. Bye.
Oh my God, that would have been so good. Oh, CJ, that was awesome. Thank you. There, people will see it. People will see on Replay Crew. They'll see it. I might play that with every single Sunday stream.
People versus Esparza, 272, Pacific 3rd, 369, 370 broadly for that. And I'll give some specific language as to the concept that I'm trying to articulate, but this is from 369. Despite our broad language purporting to address dog sniffs in general, all of our cases have therefore actually involved some admixture of considerations implying a more limited rule. We clearly rejected the broad proposition that a dog sniff of any closed container would in itself constitute a constitutionally cognizable search. And similarly, in Haley, we declined to affirm suppression on the basis of absence of reasonable articulable suspicion for a dog sniff alone. Instead, we excluded consideration of a drug dog's alert from the calculus of probable cause to support a search of the defendant's vehicle only because the dog sniff was made possible by and was therefore the product or fruit of an unlawfully prolonged detention of the defendant's vehicle. So what the Supreme Court saying is that its rationale in Haley that there was no reasonable articulable suspicion is an inadequate descriptor of the legal concern. Instead, it's that a prolonging of the stop which makes the dog sniff unjust. And when determining whether a stop has been prolonged, you're necessarily looking as to whether the police had some kind of articulable suspicion to prolong it. And so it's wrong to completely ignore the fact that the police had no reasonable articulable suspicion to prolong the traffic stop outside of Sergeant Harkin's not prior knowledge of interactions with Ms. Morgan that led him to believe that narcotics may have been in the vehicle. And so just the fact that it's a short 2-minute search, the duration of the search is not what we're talking about when we're talking about a prolonged stop. We're talking about—
How about a prolonged argument, sir? He's doing good. So you actually can listen to her all day long, as much as you want. She reads on her YouTube channel. She reads whatever we ask her to. might go how to read a menu in her accent. There it is. There it is, guys. If you want to hear her voice all day, every day, you can. Just go to her channel.
Prolonging the stop beyond the initial purpose of the stop. And the initial purpose of this stop, as I've highlighted several times, is to make a turn, was the failure to signal a turn and rolling past the stop sign. So the fact that the officers had both parties step back to the vehicle, to step them away from the vehicle and give space to conduct the search, that was all a part of the purpose. When in reality, in order to conduct the final business of the stop, all that needed to be done was Ms. Morgan to be told to stay in her vehicle while the officer completed that citation and gave it to her. So instead, we have a removal and an extension of the stop beyond the initial purpose. We can't exclude our consideration of reasonable articulable suspicion in prolonging the stop, but the concern is fundamentally that the stop was prolonged. And so on that basis, Judge, we would ask that the fruits of the search be suppressed accordingly.
Yeah, I've got some questions for you, Mr. Hall.
Yes, Judge.
Okay, so from your reading of Esparza, is it your argument that law enforcement needs reasonable, articulable suspicion to perform a free air sniff in order to prolong what was otherwise a legal traffic stop?
That's not totally incorrect, Judge. I would just frame it slightly differently from the other direction, which is—
Did you hear how he said that, guys? The judge said, you know, does he need a reason for free air sniff? No, the dog does not.
is that a free air sniff is unlawful if it is the result of a prolonged stop. So then the court must look to whether a stop was prolonged. And in determining whether the stop was prolonged, the court can certainly use concepts like reasonable articulable suspicion with regard to what was being investigated to understand if the police did prolong that stop.
So let's say this, given the precedent of People v. Esparza, and let's just for arguendo, if we agree that the traffic stop was lawful and the free air sniff did not prolong the stop, would you agree that there would be no grounds for suppression in that case?
I would disagree in narrowly. And I think this is the difference between my position and the people's. It is not that the dog sniff prolongs the stop by some specific period of time. It's that the stop is prolonged to perform a dog sniff. And so that's the distinction, is that it's not that the dog sniffs took so long, say a 15-minute, they keep running and they don't find anything, but they keep going. That is not what we're talking about when we're talking about prolonging the stop.
It might not have prolonged it, JK, because there were 2 officers there. He had the dog. So if the other officer was busy filling out the citation for the traffic violation, then they're just standing around waiting for him to fill out the citation. So this guy, the dog sniff took 2 minutes, they said. That's how long it took, 2 minutes. So while he was filling it out, he could have just brought his dog over, and that didn't prolong it. It didn't add any extra time.
In the legal sense, based on the case law, what we're talking about is a stop that's been prolonged past its initial purpose. And that as a result of prolonging it past that purpose, a free air sniff was performed. That free air sniff may have been able to be performed throughout the ordinary business of a traffic stop, maybe if this is a checkpoint, for example. But because of the nature of what was observed here, and because basically everything had been completed, they just were asking everyone out of the vehicle so that they can engage in the sniff. It essentially sets up a precedent where, because it didn't take long, they can just do it whenever, which is not really what the statute, or excuse me, what the case law really seems to be saying. The case law seems to be saying that it's unreasonable prolonging to be going after something you don't really have any reason to be looking for.
Okay, and I get that, Mr. Holland, but I'm going to start with, again, kind of a general arguendo hypothetical for you, and then I want to move to the specifics of this case. So let's say we agree that a traffic stop is lawful, that the free air sniff does not prolong, and I'm not talking about this case, I'm talking in general. There's no prolonging of the lawful traffic stop. Is there anything illegal about the free air sniff in that scenario?
If the stop is not prolonged, then no.
Okay.
If it's prolonged and then an free air sniff is done, then yes.
I got you. Okay. So given the testimony here, I believe Sergeant Harkin testified that during the free air sniff, Officer Snyder was still in the process of filling out the citation. So where's the prolonging here?
The prolonging is when they were asking the occupants of the vehicle to step out of the vehicle and then come over to the patrol vehicles. And again, this seems to be policy. Like that's kind of what I was getting at with Sergeant Harkin. I don't think we've actually ever heard why that's being done. And the answer is because I get to. I don't think that's necessarily true. I don't think that you're allowed to just ask people out of a vehicle during every traffic stop to complete a citation and open the doors and take a look around and walk the dog around when it's a simple traffic issue. So what I'm saying the prolonging was telling someone, okay, get out of the car, come over here, I'm going to fill it out. Actually, he's going to fill it out. While he's filling it out, I'm going to walk the drug dog around the car, when this is something that could have been done quickly and been disposed of. And again, there's absolutely no reason to believe that there's any sort of contraband at this time based on the activity that has been observed. This should just be a standard traffic stop. But because these are canine officers and this is the practice, they ask people out of the vehicle, they come over, and then they walk the drug dog around. And I'm saying I believe that would be an unlawful prolonging of the traffic stop.
So one more question for you, Mr. Holland. So let's say Officer Sergeant Harkin or Officer Snyder performed the free air sniff with Miss Morgan still in the car as one of the officers was filling out the citation. Anything unlawful there?
Judge, I think that would be a really different set of facts. For one thing, it would be done during the normal business of a traffic stop. There's, no removing the people from the car and extending it. I think that could be different. It's obviously not the facts before the court today.
Right.
But if it were the facts before the court today, I think that's distinguishable from what I'm arguing, certainly.
Thank you. Any rebuttal on that, Ms. Ford?
Your Honor, I think that Sergeant Harkin explained why he had Miss Morgan stand at his car, at his patrol vehicle, when he started writing the citation. His computer is there. There was information that he needed there. And while he was doing that, separately, Officer Snyder got the passenger. But I think now I've figured out that the act of bringing them out of the car is what Mr. Holland is arguing prolonged the stop, those few seconds. I don't see any demonstration to the court that that took a long time, that there was argument, that people resisted, that an hour passed. Mr. Holland initially said in the beginning of his close that the issue was confusing and that maybe there was some case law that wasn't clear or left open some kind of a door. I have litigated this in front of Judge Moschel dozens of times. There's no confusion. It is very clear. The officers are permitted to do exactly what they did, and they've done it numerous times. It didn't prolong the stop. The prolonging is, does the dog sniff prolong the stop? And it did not. The citation was being written. It was handed off to another officer who continued writing it. It took 2 minutes. When the dog sniff was done, he was still writing it. There was no prolonging. That's what the court needs to focus on. But as you see in my response, there's well-settled Supreme Court case law and Colorado case law related to law enforcement's
Yes.
right to do this, or their ability to do a legal free air dog sniff. And in this case, I say there was no prolonging. And I just ask that the motion be denied.
Thank you, counsel.
Briefly, may I respond, Judge?
You may.
Judge, again, I think the people's response highlights a misunderstanding about what the word prolong means. This is not a temporal determination, which is to say that if a traffic stop is prolonged unnecessarily by even 1 second and a free air sniff is completed around the vehicle during that time, that would be unjust under the law because it has been prolonged unjustly, unlawfully. So there is no time limit. The people keep talking about it took 2 minutes. 2 minutes too long, Judge. 2 minutes too prolonged. So that's one piece of it. The other is,
The people also said the citation still wasn't done being written when the dog completed the sniff.
the people have argued that because the police do this all the time, or because other cases have been found to suppress or rather not to suppress the results of a search by dog sniff, is completely unpersuasive, Judge. The law is living. This is why we have a Supreme Court to sort out the nuances. And while there is settled law around how the Supreme Court deals with dog sniffs now, as it applies to this situation, I think is pretty unclear. So that's what I was highlighting in the Haley and Esparza cases. I think if the court takes a look at the holdings in those cases and the facts of those cases, the court will see it's distinguishable from what we're talking about here, because what we're talking about is the police essentially using a technique that is not based in the law in any way to make people step out of the car so that they can prolong stops and engage in free air sniffs. And I think that that's the key issue here, is the prolonging unconstitutionally.
Like you said, it's not a temporal definition.
Oh, Judge, like I said, if the stop is prolonged illegally or unlawfully, even by a minute, then that is a prolonged stop, and the fruits of the search should be suppressed. That's how the law reads. Okay. Thank you, Judge.
I understand counsel's points. Thank you. Court's gonna take it under advisement. Shouldn't take long, counsel.
Thank you.
To get a written order out on this. Let's do some housekeeping here. What, do we set for trial on the 19th? Does that sound right?
It does.
So we have to wait 8 more days to find out what happened. I'm going to get this trial. I don't know if I'm going to play the trial if it's boring, but I will find out if this evidence is has been removed. And it sounds like the defense is going to lose. And the evidence is fine, just fine the way it is, and it's going to come in. All right. We're going to go to Texas now. I think I may have played one tiny clip of this one other time. I don't 100% remember, but this is a new judge in Tarrant County, Texas. And we're just going to watch it's just like that other courtroom with the dish with the sink. These are just rolling. They happen all the time. Look, hold on. Let's just see if they're happening right now. They just happen 24/7. So we're just going to watch them run through one of their dockets. Hold on. I'm just going to see if they're Texas live streams. No, wrong. That's not the right Texas. There we go. Oh, Tarrant, not Torrent. Oh, that says Torrent. But the website says it's Tarrant, Tarrant County. That says Tarrant County. This is Tarrant County Corrections. So this is jail court. Just like the other one. Let's watch.
Anybody else reading that? Ramos School. Judge, it should be everybody except for the 2 I told you about. And if you don't mind, if we could do Mr. Ramos Garcia first.
Sure.
Thank you, sir.
All right, y'all. My name's Mark Thielman. I'm a judge in the magistrate's court. The first thing I'd like to do this morning is to review with you your adult rights. When I'm finished, I'm going to ask each of you to come up to that red square.
Hell no, we're not listening to him go through the rights. We hear the rights every day. We know the rights. Oh, he's done.
All right, well, it looks like qualify. How about we appoint you one? And then if you find that you have the means to hire somebody, they'll know how to substitute in and take their place. All right? Thank you. All right. Mr. Bradshaw, you've got 3 cases we need to review this morning. You have an aggravated assault with a deadly weapon. That is pending in criminal district court number 4. You had a bond set of $25,000. You have an evading arrest. That is a misdemeanor. It is from Fort Worth. You had a bond of $2,000. You have an aggravated assault with a deadly weapon. You have a new, that is a felony offense from Fort Worth. You had a bond set of $10,000. In the event that you posted bond, you would be released to the bond supervision unit. You must report to them at the schedule they stipulate. You must avoid illegal drugs, marijuana, or alcohol. You can't possess firearms, weapons, or violate the law. You must timely appear in court. You'd be subject to drug testing, a search waiver. You must pay any fees that are required, follow any additional conditions of the partner violence supervision unit. You must be subject to, you must have no contact with the alleged victim. You would be subject to an electronic monitor. Lastly, sir, for the new aggravated assault, an emergency protective order is required by law. What that says, sir, is that starting today and for the next 91 days, that would take you up through November 8th of this year regarding LaTosha Peoples. You're prohibited from committing family violence, trafficking, stalking, sexual assault, or an act in furtherance thereof on the party named above, that you can't communicate with her in any manner except through your attorney or a person appointed by the court. That includes that you can't communicate threats to her, members of her family or household, or through third parties. You may not possess a firearm or ammunition. You may go within 500 feet of a residence at 1555 Sandy Lane, apartment number 135 in Fort Worth. So the order remains for the next 91 days. Failure to live by its conditions may result in additional charges being brought against you. Lastly, I must tell you that no person, including a person who is protected by this order, may give permission to anyone to ignore or to violate any provision of the order. During the time in which the order is valid, every provision of the order is in full force and effect unless a court changes the order. Here's what that last bit of legalese means, sir. If Ms. Peoples were to call, text, Facebook message, contact you in any way and say, come on over, it's okay. I didn't mean for this to happen. I'm dropping these charges. I want to forget the whole thing. I don't know anybody involved. I got no idea what she might say. But talk to your lawyer about how to get it changed. As I said to begin with, the order is required by law for the offense that you've been charged with. So if you're found at that address or engage in any of those other behaviors, even with her permission without getting it changed, it's Class A misdemeanor, it's a violation. It risks getting you back down here in the basement hanging with us. Do you understand? Fantastic. Kindly step over, sir. I'll get you some paperwork. Benjamin, is it Doggett?
Doggett.
Okay, I'm sorry. I didn't hear you. How am I supposed to pronounce it?
Doggett.
Doggett?
Yeah.
All right. Did you understand your rights, sir?
Yes.
Are you a U.S. citizen?
Yes.
All right. And do you need a court-appointed lawyer or try to hire someone to help you, sir?
Court-appointed.
Very good. We'll take a look. Sir, you have a warrant for a false drug test device. It is a...
If they did, they did call one other person. If they did, that means they're misbehaving and they need to get them out of there right away. So we didn't see any screaming or tasing going on.
A misdemeanor. It came from the sheriff's office. You have a bond set of $1,000. In the event that you posted bond, you must report to the bond supervision unit, continue to report the schedule they stipulate. You must avoid illegal drugs, marijuana, or alcohol. You can't possess firearms, weapons, or violate the law. You must timely appear in court. You'd be subject to drug testing, search waiver. You must pay any fees that are required. Follow any additional conditions that your court would impose. Could you hear and understand me, sir?
Yes.
Okay.
Yeah.
Have you had any contact with Georgia about your situation there?
Yes, I already saw a court on Tuesday.
You already saw court. You already saw him there.
Yes. Well, not yet. I'm waiting to get extradited.
Okay. Well, you may come back down to, have you been to see a magistrate like me to talk about your extradition situation?
Yeah, I already talked to him.
Okay. All right. Well, okay, good. Then you, again, I just didn't want you to be surprised if Georgia took some action. So as long as you know what's going on, it'll all work itself out in time. Good luck to you, sir. Step on over. Taylor Dawn.
Yes, sir.
All right, Mr. Dawn, stand where you need to hear me. Did you understand your rights?
Yes, sir.
Are you a United States citizen?
Yes, sir.
You need a court-appointed lawyer, Mr. Dawn. You're going to try to hire someone to help you.
Court-appointed.
Thank you, sir. All right, Mr. Dawn, you have a criminal mischief charge. It is a misdemeanor. It came from Fort Worth. You had a bond of $1,000. You have an abandoning or endangering a child. That is a felony offense from Fort Worth. You had a bond of $10,000. You have an assault on a family or household member with a prior conviction. That is a felony from Fort Worth. Your bond was set at $40,000. In the event that you posted bond, you would be released to the bond supervision unit. You must report to them at the schedule they stipulate. You must avoid illegal drugs, marijuana, or alcohol. You can't possess firearms, weapons, violate the law. You must timely appear in court. You'll be subject to drug testing and a search waiver. You must pay any fees that are required and follow any additional conditions of the Partner Violence Supervision Unit. You must have no contact with any alleged victim, and you would...
Whoa, wait a second. Hold on a second. I'm going back to the other case. Can we go back to the other case for a second? If she is a known drug dealer and she has been convicted of that in the past, of a felony, then she waives her Fourth Right Amendment. She's allowed to get searched whenever for whatever reason, right? So it doesn't matter. It doesn't matter. Why didn't he say that? Why didn't they say that? Or is it different in each state? No, I don't think so. If she has a felony, she's allowed to be searched. With a dog, without a dog.
be subject to an electronic monitor. You also have an emergency protective order, sir. Now, What yours says is that starting today and for the next 61 days, that would carry you up through October 9th of this year, regarding Corey Bryant, Zendaya Dawn, Kiza Dawn, Kari Dawn, Dracaris Dawn, Kalisha Dawn, and Koa Dawn, and apologize for my mispronunciations. You're prohibited from committing family violence, trafficking, stalking, sexual assault, or an act in furtherance thereof on a party named above. That you can't communicate with them in any manner except through your attorney or a person appointed by the court. That includes that you can't communicate threats to them, members of their family or household, or through third parties. You may not possess a firearm or ammunition. You may not go within 500 feet of a residence at 9914 Plainfield Drive in Fort Worth, or schools at 8901 White Settlement Road in White Settlement, or 601 Blue Hedge Drive in Fort Worth. So the order remains for the next 61 days. Failure to live by its conditions may result in additional charges being brought against you. Lastly, I must tell you that no person, including a person who is protected by this order, may give permission to anyone to ignore or to violate any provision of the order. During the time in which the order is valid, every provision of the order is in full force and effect unless a court changes the order. Same speech as the earlier gentleman got. I don't know anybody involved. I got no idea what they might say. But if they say, come on over, it's okay. I didn't mean for this to happen. I'm dropping these charges. I want to forget the whole thing. You talk to your lawyer about how to get the order changed. Don't just show up. You risk getting you back down here in the basement hanging with us. You understand, sir?
Sorry.
All right. Kindly step over. I'll get you some paperwork.
No question is, if I do my bond, if I bond out, I just have to wear an ankle monitor.
Yeah, you'll have all the, you'll have the ELM and the other conditions of the Partner Violence Supervision Unit, and then you'll have the restrictions of the EPO. All right, but they'll go over all that with you when you get across the street.
Okay.
Good luck to you. Christopher Dews?
Here, sir.
Yeah, come on up. Stand where you need to hear me, Mr. Dews. Hey, did you understand your rights?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
You're going to need a court-appointed
With that accent, no one's going to say Delta Dawn.
lawyer, Mr. Dews. You're going to try to hire somebody.
We'll try to hire.
All right, you try. You let us know if it doesn't work out for you. We can revisit that. So you have an assault causing injury to a member of your family or household. Mr. Dews, you were arrested on a warrant out of Arlington. You had a bond of $1,000. In the event that you posted bond, you must avoid illegal drugs, marijuana, or alcohol. You can't possess firearms, weapons, or violate the law. You must timely appear in court. You'd be subject to drug testing. You must follow any additional conditions that your court would impose. You're to have no harmful or injurious contact with the alleged victim. Could you hear and understand me okay?
Yes, sir.
All right. If you'll kindly step over and follow the officer's instructions, please.
Yes, sir.
Good luck to you. Carlos Galindo Batista.
Yes, Your Honor.
Hey, Mr. Batista Galindo, how about you, sir? Did you understand your rights?
Yes, Your Honor.
U.S. citizen, sir?
Yes, Your Honor.
You need a court-appointed lawyer, Mr. Galindo? You're going to try to hire somebody?
I will try to hire somebody, Your Honor.
All right, you try. If it doesn't work out, you let us know. As I said at the beginning, if you do end up remaining in custody more than 7 days, we'll likely go ahead and appoint you one automatically. That won't stop you from hiring. I just don't want you sitting in jail too long without having somebody on your side. You understand?
Yes, sir.
Very good, sir. You have an aggravated assault with a deadly weapon. Mr. Galindo, that is a felony. It comes from Fort Worth. You have a bond of $15,000. Should you post bond, you must avoid, you must report to the bond supervision unit, continue to report at the schedule they stipulate. You must avoid illegal drugs, marijuana, or alcohol. You can't possess firearms, weapons, or violate the law. You must timely appear in court. You'd be subject to drug testing, a search waiver. You must pay any fees that are required and follow any additional conditions that your court would impose. You're to have no contact with any alleged victim. You must provide a DNA specimen if requested. You must stay off the premises at 6014 Camp Bowie Boulevard in Fort Worth, sir.
Yes, Your Honor.
You understand your situation?
Can I ask questions?
You can ask. I'll try to answer them if I can.
If the person never got touched, how was it aggravated assault? I was just asking that. That's pretty much it.
Well, all right. You can make aggravated assault first off, you and your lawyer sit down and then talk about it in more detail. They allege that you used or exhibited a deadly weapon in the course of committing the aggravated assault. So if you threaten someone with a knife or gun or, any other deadly weapon, it can be a felony offense even if they weren't touched. But again, we're not deciding today whether you're guilty. That's what the police say happened. You talk to your lawyer about everything that you say happened. They'll know. They'll have access to the police reports. They'll know what the police say, but it's going to be mission critical. They know what you say. You understand? All right. Step on over, sir. I'll get you some paperwork. All right. David McCain. Hey, Mr. McCain, how about you? Did you understand your rights?
Sir.
U.S. citizen? Your troubles are out of Delta County. You need a court-appointed lawyer when you get over there. You're going to try to hire somebody. I cannot appoint a lawyer for Delta County. I will tell them that you need a court-appointed lawyer. Don't assume they're going to read my paperwork. When you get there, tell them yourself. Now, they've got an evading arrest with or detention with a vehicle. They allege a probation violation. They've set you a bond of $150,000. If you were to be able to post that bond, any prior bond conditions would remain in effect. They have a resisting arrest charge. Also, that is a misdemeanor also from Delta County. They have set you a cash bond of $1,000. Any prior bond conditions would remain in effect there. Now, do you have any local business, or are these holds the only thing keeping you in jail?
That's pretty keeping me in jail. But I got a question though. That probation violation part, I had got picked up in Saxy, and when I got picked up in Saxy, it was for probation violation. And when I called Saxy to let them know, like, is my paperwork sent over to Delta? It's like, yes, it is. So when I contacted Delta, they said that I've never been picked up. I've never, like, it said in that I've never, like, been picked up at all.
I tell you what, I'm going to cut you off. Here's why. Everything we're saying is being recorded, and I don't want you to be talking about anything that you really should be talking about your lawyer in private. Okay. I don't have any idea what Delta County says you did or didn't do. They didn't tell me that. They just said, tell the man that we've set his bond at $150K and then a $1,000 cash bond. So again, if you don't have any local holds, they'll be notified they need to come get you. If they say they realize they've made a mistake and they tell you to tell the jail to lift the hold, Tarrant County doesn't want to feed you one day longer on our dime than we have to on their hold. We're required, if you don't have any local or business or other local holds, to hold you for 11 days. So again, all right. Now that's assuming you don't have any other business that might slow it down a little bit. But we'll get in touch. The sheriff's office will get in touch with Delta. They'll tell them you're in custody, and they'll be notified to come get you. And then it'll be on Delta to either help you sort all this out. Okay?
So can I ask for a bond reduction, or I can do it?
You're going to have to wait till you get there. Again. All right? Good luck to you. Is it Jacob Regiman?
Yes, sir.
How should I mispronounce it, sir?
Regimon.
Regimon. Mr. Regimon, did you understand your rights?
Yes, sir.
Are you a United States citizen?
Yes.
Do you need a court-appointed lawyer? Or are you going to try to hire someone to help you, sir?
I believe I will get a court-appointed lawyer, but my mom might hire me a lawyer.
All right. Well, it looks like you qualify. We'll get you a court-appointed lawyer started. If your mom hires somebody, they'll know how to substitute in. Mr. Regimon, you have a possession of drugs penalty group 2. That is a felony. It came out of the sheriff's office. You have a bond of $3,000. In the event that you post bond, you must avoid illegal drugs, marijuana, or alcohol. You can't possess firearms, weapons, violate the law. You must timely appear in court. You would be subject to drug testing.
Jenny, how are you? It's been a while. I was worried.
And a search waiver. You must provide a DNA specimen if requested and follow any additional conditions that your court would impose. You understand your situation?
Yes, Your Honor.
All right, please step over. I'll get you some paperwork. All right, Derek Rogers. Please stand where you need to hear me, sir. Mr. Rogers, did you understand your rights?
Yes, sir.
U.S. citizen, sir? Do you need a court-appointed lawyer, Mr. Rogers, or will you try to hire an attorney to help you?
Court-appointed.
Thank you, sir. Mr. Rogers, you have an assault on a family member with a prior conviction. That is a felony offense. It is pending in, so it looks like you're on probation out of criminal district court number 3. The DA's office has filed a motion to revoke your probation. You also have a violation of a bond or protective order. That's in county criminal court number 5. That is a misdemeanor. They allege that you failed to appear and your bond was forfeited. In the felony case, on the assault charge, your bond was set at $8,000. On the violation protective order, your bond was reset at $10,000. In the event that you posted bond, you would be released to the bond supervision unit for them to review your ongoing conditions. You must timely appear in court, sir. You understand your situation? Please step over, sir. I'll get you some paperwork. Is it James Schleier?
Yes, sir.
Did I pronounce it correctly?
Yes.
Mr. Schleier, did you understand your rights?
I do.
Are you a United States citizen?
I am.
All right. And it looks like you maybe hired Abe Factor to help you with your troubles?
That's right.
All right. You're on probation out of criminal district court number 3 for an injury to a child, the elderly, or the disabled. The DA's office has filed a motion to revoke your probation. The judge of your court wants to be involved in setting the bond. So right now you have a no bond hold. Abe will have to go by and see the judge if you want to get a bond set. You understand? All right. Very good, sir. Step over. I'll get you some paperwork. Chad Smith.
Yes, sir.
Please come up. Mr. Smith, did you understand your rights? U.S. citizen?
Yes, sir. Yes, sir.
Court appointed, are you going to hire?
It's only a ticket. Like, I didn't know if I needed a lawyer for
Well, I tell you what, you try to hire somebody. If you find that you can't, you let us know. You have a driving with license invalid with a prior conviction. That is it's a Class B misdemeanor, so it's one step above a ticket. It comes out of Fort Worth. You have a bond of $500. You must avoid illegal drugs, marijuana, or alcohol. You can't possess firearms, weapons, or violate the law. You must timely appear in court. You might be drug tested. You may not drive or operate a motor vehicle unless you have a valid driver's license. You understand your sitch?
Yes, sir.
Step over. I'll get you some paperwork. Pancho Villarreal.
Yes, sir.
Mr. Villarreal, did you understand your rights?
Yes, sir.
U.S. citizen?
Yes, sir.
Needing a court-appointed lawyer, sir?
Yes, sir.
Mr. Villarreal, you have a failing to register charge. That is a felony. It came from Fort Worth. You have a bond of $10,000. In the event that you posted bond, you must avoid illegal drugs, marijuana, or alcohol. You can't possess firearms, weapons, violate the law. You must timely appear in court. You might be drug tested. You must follow any additional conditions that your court would impose. You must complete and maintain any keep current your sex offender registration, sir. Please step over, Mr. Villarreal. I'll get you some paperwork. For me.
Back to 21.
This is in the jail. We are in the jail. We're in the basement, actually.
Hello.
Judge, please quit calling me in the middle of my live stream. Get back to work.
And I'm sorry, I missed your name, sir? Oliver, my name is Mark Thielman. I'm a judge in a magistrate's court in Fort Worth, Texas. Over in the jail is Do Lay. I need to review some rights with him and talk to him about a pending criminal case. Oliver, do you swear that you'll truthfully translate from English to Burmese and Burmese to English to the best of your skill and ability? If I give you a telephone number, there's an officer standing by a speakerphone who will connect us and we can begin. Are you ready? Area code 817-884-30.
I'll fake it.
Oh shit, holy shit, holy shit.
This is totally me saying nice to meet you. This is totally me saying it. See how fluent I am? You had no idea.
Mr. Lane, your rights are as follows, sir. You have the right to hire an attorney to represent you, sir. You have the right. I'm sorry? Yes. Right. You have the right to have a lawyer with you prior to and during any interview or questioning by police or attorneys representing the state, sir. Okay. You have the right to remain silent, sir. Okay. You are not required to make a statement, and any statement you make can and may be used against you in court, sir. Yeah, you have the right to stop any interview or questioning at any time, sir. If you're not a United States citizen, you may be entitled to have you notify your country's consular representative here in the United States, sir. Do you understand your rights, sir?
Yes.
Right. Are you a U.S. citizen, sir?
Yes, it is a visa. Yes.
Right. And you already have hired Al Robinson to help you, is that correct, sir?
Can I say I believe so.
You're charged, you have been driving while intoxicated charge in County Court number 3, sir.
Okay.
Your bond was held insufficient, sir. It was reset at $750, sir. If you postpone, you have to report to the bond supervision unit, sir. Your prior bond conditions will remain in effect, sir.
Okay.
Including your alcohol monitoring device, sir. And you must timely appear in court, sir. Do you understand, sir?
Sure.
Yes. Please step down and I will get you some paperwork, sir.
But me go to school, I see the cool.
I just have one question. Please go ahead.
Aku lama ni lama saya ni mah tu no ada belum ni mah tu kau desi jalan ama di okay sila bahasa dia mah tapi lah tu di lokal meni anak tu no di yoban lah ho di female lom lola elo tu dah tu no ada ayah amar kursi dah orang. Amar tu tu no primera la película se llama tu de no para de lo. Aku baru tadi lah ni malah tu no kau masih dah tu no belum yang ni.
Yeah, of course Monday, August 11th, I had a different case that I was coming here to pay the fees and fines, that kind of thing, and also appear the court. The next court day is August 11th.
And I was actually coming here to pay the fees and find the best friend. I got detained, so I don't know what to do about that court date Monday.
Well, you do not post, if you do not pay bond before Monday, sir.
On the, can you finish the sentence, please?
Sure. If you do not make bail before Monday, it will be the jail's responsibility to get you to court, sir.
저기 방송은 듣나보노. 방송은 듣네. 하나 이 만들면 이 방송의 설정이 그냥 통째가 알아. 얘네 또 뭐. 그냥 방송 설정 넣기는 나 만들자 이 상황이 이거 상황이 이거 그냥 그냥 용 거를 만들자.
If you do post bail and are released over the weekend, show up for your court at the time that you were supposed to, sir.
The
Gelo Amata to not top power the part of what it now. How much?
I was just wondering whether I would get arrested again when I go to the court hearing.
Well, if you do not have any other warrants, you should not get arrested, sir.
그냥 그 소가의 분위기가 파울로 우연도 가해요. 하면 되는데 그것에 우연히 하고 또 마마 소가는 질문아.
So today.
I don't believe I have any further warrants.
You can ask the officers to look for, to check on your behalf, sir.
그냥 선생님 아시게 얘기 내가 당연히 그야말로 얘기 내가 저처럼만 고양이 시대라고 하고 안에 고양이를 봐라. 안에 고양이 통달아 시대라고 지금.
Okay, please sit down and I will get you some paperwork, sir.
now
Okay, yes, sir.
Thank you, Your Honor.
You're welcome. Oliver, that will conclude our hearing. Thank you for your help today.
Thank you for your justice.
We made it through Texas. In the jail. It's like Detroit. That one, you know what I'm talking about, in Detroit, where the in the jail where they come through and we get the craziest people in there. And then we got Arizona, Maricopa County. I get a lot of jail feeds from Colorado. I could probably do a 6-hour live every day on just jail feeds from Colorado. Maybe I should get them more. Like, I think I have one in here. We're not going to go through it today, but I think, hold on, I think I have one that I have to look through. Is that a jail feed? No, that's not a jail feed at all. Neither is that. This is, I'm not going to play this today, but this is the same jail, just a different magistrate, because they rule it. They keep going through. Thought I had another jail feed, but maybe it's upstairs. All right, guys, we did it. Thank you so much for coming out today. I really appreciate it. I will see you all again real soon. OJ's about to start. Have a great day, guys. Bye.
Got these life echoes, digital dreams. Through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted charm. In a way, there's no alarm. Streaming tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Her eyes near a sky so blue. In her jokes, there's a truth so true. With each stream, she brings the light. Turns dark days into bright. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor, dark and twisted charm. In a way, there's no alarm. Streaming tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Kathy's laugh